Okay, so first of all, I'm gonna say good morning, good afternoon for whoever's online and it's afternoon in their time zone. First, I would also like to say that I'm honored to be here and to participate in this intervention. Um, I'm gonna thank the colleagues from the Validity Foundation also for organizing this. And also thanks to the colleagues who are also supporting on the technical stuff, on the technical staff, the interpreters. Also, thank you for this service. Um, Let me introduce myself. I'm Edwin Cantu. I'm an Access to Justice Specialist at UNODC. UNODC stands for the United Nations Office on Drugs and Crime. In the United Nations office, we have a very committed team that works on access to justice topics, which is what we're going to talk about now. Just to have a quick overview, what we will be doing for around 20 to 25 minutes is to give a short introduction to the topic of equal access to justice and access to justice for women and children with disabilities, particularly focusing on internationally agreed standards and some work that the UNODC office has been implementing that is related to this topic. And of course, some of the lessons that we have been learning along the way of implementing disability inclusion initiatives. Also, can you confirm if the slide changed?
Yes, it did.
Okay, perfect. So I would like to start this presentation with a key question to all of this. Whenever we read the concept of equal access to justice for all, or let's say, whenever we read the concept of access to justice, what do we mean? What do we actually mean when we say this? I would also like for you to think about the answer to this question. What do we mean when we say equal access to justice for all or access to justice? Because the concept and the answer may depend for whoever's thinking about the response. For instance, for victims, the concept of access to justice may mean the possibility of filing a report with police or with law enforcement, to reach out to police or to law enforcement officials and said, there has been a crime that has been committed. For some, it may be, this may mean equal access to justice for all. For victims also, access to justice may mean the possibility of filing a complaint when disengagement with law enforcement is not responsive to their needs. So that this specific behavior by the public personnel needs to be investigated. And if determined that there was an improper conduct, will access to remedies. Also for victims, the concept of access to justice may mean fair treatment. That whenever I'm engaging with law enforcement, with prosecution, with legal aid service providers, that I'm being treated fairly. Also, access to justice for victims may mean access to medical service, psychological service, social service, being able to participate in the criminal justice process, that the victims are represented in the criminal justice process and that they have a voice within this process. Now, this is for what people who are being victims of a crime may think of when they see access to justice. Now let's think about the perspective of a witness. From the perspective of a witness, what does access to justice mean? It may mean access to information about their rights. Now, there's an additional question to this. What information am I receiving, and I'm receiving the proper information, and is this information in an easy to read format, in an accessible way? I can understand this information. Another element that for access to justice from the perspective of the witness may mean to receive the appropriate legal advice, on how's the process going to flow. It may also mean protection from risk or from harms. related to the criminal justice case that it is involving. So we have that victims may think of access to justice in a different perspective, witness from another perspective, but what about the suspects of crime? Well, I'm forgetting this, sorry. For suspects or accused of crime, access to justice may mean, for instance, that the treatment that they're receiving from the criminal justice practitioners is free from torture, free from ill treatment. It may also mean that they are being informed about the charges that they're being accused of, that they're informed about the status of their case. It may be also related to the possibility of having a timely and appropriate trial. And of course, a key component for access to justice from the suspects or for those suspect or accused of crime may also mean that they are being treated as innocent until proven guilty. So we have these three perspectives from victims, witnesses, and suspects. And from a different point of view, we are referring basically about safeguards, about procedures, about services that facilitate their engagement with the criminal justice system. Now, here's a bit more complicated. And the way we make it more complicated is if we add the concept equal and for all. Equal access to justice for all means that whoever engages with the criminal justice system has equal opportunities to fully receive those services, to receive those interventions in a manner that are being equally treated throughout the process. But the complication here is that through research, we have identified that not all individuals and not all groups are fully accessing equal access to justice for all in equal terms. For instance, women and children, they face a different set of challenges that hinders their ability to properly access justice in equal terms. So now we will need to be thinking about women who are victims of crime and what are their specific needs to properly receive justice. And now let's think also from the children perspective, what the children who are suspect or accused of crime need to properly access justice. Because both women and children, along with other marginalized and discriminated against groups, face different types of barriers, which we will be talking about later and throughout the day, actually. Of course, when we add another component in this mix, and we refer to women with disabilities and children with disabilities, we may also need to consider how do we promote equal, fair, and humane treatment for them to fully engage with the criminal justice system and the criminal justice processes, so that they have, so that they may receive justice in equal terms, along with other individuals and groups. So for now, what I want you to understand is that the concept pretty much depends from the different points of view. And when we say equal, we're noticing that there are some groups which are being left behind. Women and children, women with disabilities and children with disabilities, they're being left behind on the criminal justice responses, services, and procedures. Now here it's important to refer to the United Nations General Assembly Resolution 78-227-227 on equal access to justice for all. This resolution was approved last year on December, and it's important because it provides a framework in which member states are identifying the need to further commit to pursue different types of strategies of initiatives to enhance responses for all those individuals and groups who are being left behind. Here, I must also say that even though there is no universally agreed definition of what equal access to justice for all in the criminal justice system means, there is no universal definition for this. However, based on what I've referred to in the previous slide, we can identify that there are certain elements, and those certain elements are reflected as rights contained in the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. For instance, I was speaking about, from a suspect perspective, access to justice may mean that this person is being considered innocent until proven guilty. This is a right considered in the International Covenant on Civil and Political Rights. From the victim's perspective, the possibility of accessing medical, psychological services and support is also considered as a right in the International Covenant on Economic, Social, and Cultural Rights. So even though we don't have a concrete definition on access to justice, we know that there are elements that links the concept to the rights, and these rights are being recalled by member states in the Equal Access to Justice for All resolution from last year. Now, on this same vein, I must also add that along with this international human rights legal framework, it is noted that the Convention on the Rights of Persons with Disability is added within the whole framework on the Equal Access to Justice for All reflections. So, of course, to properly guarantee equal justice for all, we need to consider the particular barriers and challenges people or persons with disability are experiencing while engaging with the criminal justice system, and also considering if they're women, children, or from another marginalized group. In this sense, of course, it's impossible to, well, I'm gonna rephrase that. It's very important to take an understanding of the Convention on the Rights of Persons with Disabilities in a holistic, comprehensive way. But just for this particular introduction remarks, I would highlight the Article 13 on access to justice, which is referred there. Of course, as I was saying, we must also consider that there are specific mentions on accessibility, specific mentions on reasonable accommodation, on procedural adjustments, but particularly focusing on access to justice, member states agreed on three things: on promote equality, as I was previously referring, make sure that people with disabilities can access the criminal justice system equally. Member states also agreed on the provision of support to fit their needs so that they can take part in legal processes and investigations. Now, supports that fits their needs. This is particularly interested in from a victims, witness, and suspect perspective. What specific support does a children in detention needs to fully access justice in equal terms, for instance? And a third reference in the Convention on the Rights of Persons with Disability is that police, prison staff, and others in the justice system should be trained to help and support people with disabilities. Now, of course, there are ongoing initiatives which are related to training to police, prison staff, prosecutors, legal aid service providers, facilitators, mediators, court clerks, or judges. However, there's still a long way ahead to fully guarantee that this training reflects a change in attitudes and behaviors so that this enables people to actually access justice. In this context, it's very important to talk about the UN standards on norming crime prevention and criminal justice related to access to justice. Let me say this. Let's understand that all around the world, all around the globe, there are different legal traditions and differences in the criminal justice systems. So a key question here is, how can we promote and how can we practically promote justice services that are compliant with the international human rights legal framework? How do we translate what's written on the international human rights legal framework into practice? And here's why we talk about the importance on the UN standards and norms in crime prevention and criminal justice. Because these norms are internationally agreed by member states, and these norms provide guidance and minimum standards of the overall criminal justice processes and systems. So these standards and norms, they provide a benchmark in which states are committed to pursuing to guarantee that everyone may access justice in equal terms. Just to give you a quick overview of some of the UN standards and norms that are related to access to justice, and I believe it's important to refer this because we will be addressing them throughout the whole day. One of the key internationally agreed standards are relevant for access to justice, and particularly for persons with disabilities and women and children with disabilities, is the possibility of accessing legal aid. Legal aid as a standard is referred in the UN principles and guidelines on access to legal aid in the criminal justice system. And it provides key guidance on legal assistance, representation, and support at different stages of the criminal justice process. Legal assistance, support, and representation in the pre-trial, trial, and post-trial process. For victims, for suspects accused of crime, and for witnesses. Now, these standards and norms, particularly on legal aid, they highlight the importance of the availability of legal aid. And here we could keep on discussing about the barriers. For instance, let's say, okay, yes, there is legal aid service provision for those who are suspects or accused of crime, but perhaps not for victims, or perhaps not for witnesses, or perhaps the legal aid service provision is only in the main cities within a specific country. So one of the key aspects on legal aid is the availability of legal aid. We will quickly refer this more in detail on the last slides, in which we talk about how the use of technology can facilitate access to legal aid so that everyone may have access to legal support or legal advice, regardless if they have direct contract with a legal aid center, let's say. No? But a key important measure here is the availability of legal aid. Legal aid needs to exist. Now, let's say that legal aid exists. Now, another key topic here is how do we ensure that the legal aid service provision abides to a certain quality standard? How are member states establishing mechanisms or strategies to promote quality on legal aid? And a third aspect it's also included on the principles and guidelines on this is legal aid must address the specific needs of individuals and groups in marginalized or vulnerable situations. And of course, for the context of this topic, of these discussions, it is very relevant. Let's say that there's availability of legal aid, quality of legal aid. However, this legal aid has not been thought for addressing the specific needs of persons with disabilities. Now, there's we can reflect a bit more on this. How do we sensitize the legal aid service provider? What does he, she, they need to know? How could they rearrange the information he, she, they has in an accessible and friendly format. What are other adjustments that this person will need to do in order to be responsive of the people, the person or children with disability? So as I was saying, the UN principles on guidelines on legal aid, they provide us with a set of guidance for all member states, regardless of the legal tradition. So we're walking towards that. And from the UNODC side, we're supporting member states to walk towards abiding with this internationally agreed principles. On policing, also a very huge and important topic. How is police or law enforcement officials engaging with persons with disabilities? How are they engaging with women with disabilities, with children with disabilities? Now, I must also say that the code of conduct for law enforcement, officials, in its Article 1, it addresses that the duty of law enforcement is to serve the community and to protect individuals. An internationally agreed standard on policing is that law enforcement officials, to fulfill their duty, is to protect individuals and serve community needs. How is police engaging with victims, suspects of crime and with witnesses in an order that is supportive to the community needs? This will be particularly interesting when we discuss, for instance, on the next topic, when we discuss, for instance, persons with disability, persons with psychosocial disabilities, for instance, who are in a crisis scenario, let's say. How is police responding to this very specific setting, and how is they engaging with other community service to provide a human rights compliant response to these cases? Because the code of conduct is quite clear in its Article 1. The duty of law enforcement is to serve the community and protect individuals. How is law enforcement serving the community and protecting the individuals in these very specific cases? For instance, let's say in crisis scenarios. And this also takes us to the other norm and standard on this. The basic principles on the use of force and law enforcement, the basic principles on the use of force and firearms by law enforcement officials. These basic principles, they provide guidance on how and when to use the force and the importance of accountability. As I was saying, particularly in cases of psychosocial disabilities, which people may be at risk of unlawful use of force, which may lead to injuries and trauma. And if that's the case, that this person may have access to reporting misconduct, ill treatment, and torture, for instance, as I was referring previously on the first slide. So the basic principles here, they are relevant to guide law enforcement and police interventions, particularly also with persons with disabilities and with women with disabilities. I must also add here that both for the legal aid and for policing, UNODC has developed a set of manuals and training tools for law enforcement on this. On another topic, on victims, the internationally agreed norms and standards, they include the importance of victims to participate in the justice process. So it was previously considered that victims reported a crime, but their engagement with the criminal justice process was only that. But now, how do we promote victim participation up to the point that this person wants to, of course, in the criminal justice system? Because this is also related to a restorative process. The victim is engaged in the process in a way that they declare the harm that has suffered. Therefore, they're looking for remedies, reparations, or compensations. Also, that the UN standards and norms, they refer to the importance of receiving fair treatment. Receiving fair treatment that takes into account the trauma they have endured. And now this is also particularly very important and interesting and I'm going to relate it to the previously to referred standards. Trauma-informed approaches from police, trauma-informed approaches from prosecution, trauma-informed approaches from the legal aid service provider. Think of a scenario in which law enforcement is engaging with a deaf girl, and I'm sharing this scenario because a law enforcement official from Mexico, he actually went ahead and shared this with me. There was this case in which a police intervened in the crime scene. He noticed that there was this girl. He noticed that this girl is deaf. So he called for support from a deaf interpreter within the police, which is not always the case. And they noticed that this girl with this deaf girl, she didn't knew Spanish, and she also didn't know Mexican Sign Language. This case is based in Mexico. So this girl was deprived of a proper language or a language on their own. Not to say that she didn't communicate. Of course, she did communicate. However, she was being deprived of a language, sign language, deprived of Spanish as a language. You know, so how is police going to respond in a human rights compliant way with a trauma-informed approach in these particular scenarios? And of course, here we go back to the UN standards and norms, the importance of promoting victim-centered approaches that also consider this. So we have a comprehensive and holistic reading of this. The standards don't go by themselves. They are also interlinked because we're compliant to the international human rights framework. On another topic, restorative justice. So restorative justice, or the promotion of the use of restorative process, is a way for people to engage in the criminal justice system without going through a trial phase. Try to establish an agreement between an agreement or an understanding between offender and victim that does not follow necessarily the whole criminal justice process or criminal justice procedure. Now, a key point here is that restorative justice practices, although they are being used for to alleviate the congestion of cases, to alleviate backlog in the criminal justice system, the restorative justice process must be happening only when consent is voluntary and informed. Key considerations here: restorative justice process must only happen when it's voluntary and informed. And another addition that's also being referred to in the standards and norms is that this process must be fully understood. Now let's think about children participating in restorative justice process. Their participation must be voluntary, must be informed, and it must be fully understood. So of course, now there's the challenge for the criminal justice system and service providers to facilitate information in a way that is accessible for them so that they understand what the process is going about. And since we're referring to criminal justice standards, it's of course important to refer them the Nelson Mandela rules and the Bangkok rules. Here, I must add that the standards refer that prison staff must provide reasonable accommodations and adjustments as necessary. And this is also related to what's been added on Article 13 in the CRPD. Prison staff, police, and other criminal justice professionals must be trained on these matters. And of course, this is something that the standards and norms also adds the importance of prison staff to provide reasonable accommodations and adjustments as necessary. And not only this, for persons with disabilities, women with disabilities, and children who are in detention center, the importance of providing information in accessible formats so that these persons may also understand either the process, the service, the ongoing situation that concerns them. And a key reference here is that what they're trying to promote is to ensure the participation of prisoners in the process that concerns them, of course, so that they're not being left behind and they're also included in the prison administration and the prison service provision. I must also highlight here, particularly for the Bangkok rules, that they add specific support for women with disabilities, the need to establish a standard for women, the need to provide a standard for those who work in the prison system to ensure that the needs of women prisoners are being fully addressed, particularly for those with mental and intellectual disabilities. How are the prison system, prison staff going to address their specific needs? How are they going to link them with support persons whenever it's necessary, for instance?
Edwin, I'm so sorry to break in. It's just I think we are running a little bit out of time, and I know you had a lot more to share about the challenges and UNO Odysseus response. And I'm really sorry to be the bad guy with the timekeeping, but I think we can still wrap up just to let you know.
Okay, no worries. I'm sorry, I wasn't aware of the time. Then let me just quickly jump into the lessons learned. Some things that we wanted to share with you. So the importance of strengthening the participation of persons with disabilities at all stages of program implementation and promote consultation mechanisms. The UN, on the UN Disability Inclusion Strategy, there's a particular target that refers to need to promote disability consultation process. And the proper reports on the disability inclusion process, they refer that we are lacking on the consultation mechanism. Consultation mechanisms are absolutely relevant for program implementation because we don't want to only mainstream disability inclusion throughout the process, throughout the program implementation. We don't want to only be up to that. We also want active involvement and participation of persons with disabilities. Another key lesson learned is the inclusion of support persons throughout the justice process. This is something that has been referred several times by member states, but also by civil society organizations and academia, is that people who are engaged in the criminal justice system, either as victims, suspects, or witnesses of crime, they engage better with the system if they have the support from a support person. And there are several mechanisms that are ongoing, depending on the state. This is something that we highlight and we should definitely go a bit more into. The importance of conducting individual assessments of the needs of suspects, victims, to understand what procedural or reasonable accommodation or adjustments are needed. And I will link this, the conducting individual assessments, with a point that's below, leveraging the use of technology. Because of COVID, we have understood that technology is a powerful tool to enhance equal access to justice for all, but it has also its limitations. How do we ensure that the participation of the person, how do we ensure the proper participation? How are we responsive to their needs? And for that, we must also take into account the need for implementing individual assessment, a case-by-case scenario in which criminal justice practitioners, they're aware of what needs to be done in this particular case. Mainstreaming physical and cognitive accessibility. This is something that me personally have been promoting so much. Cognitive accessibility. Information needs to be out there in a way that everyone understands them, with or without disability. That is what we're trying to promote, cognitive accessibility. This is particularly important for, let's say, legal aid service provider, that just by engaging with a lawyer or with a legal aid service provider may be difficult. How do we facilitate that those interactions are much more amicable, that they're more friendly, that the information is easier to access and to understand? The development of data collection schemes. This is a topic that we had noted that there's many work to be done. Data collection schemes, particularly from an intersectional approach. Let's say women are being victims of crime. Women with disabilities are being victims of crime. But also racialized women with disabilities are being victims of crimes. Of which crimes, for instance? Let's think of girls with disabilities. They're being victims of crimes. Of which crimes? So we need to keep on gathering data and promoting this. And just on the last point, addressing hate-based crimes against persons with disability. This is something that we very much keep pushing forward to work with member states. How are we understanding hate crimes and hate crimes based on disability, so that we can prevent, investigate, and prosecute hate-based crimes across different types of backgrounds. It may be related to race, ethnicity, gender, but also how are we investigating those specific hate crimes that are related to disability. And as I was referring previously, maybe there's the possibility of linking hate crime with restorative justice processes. There's an area to keep on pushing forward there. And there's also the interest from member states and civil society to keep digging a bit further into understanding hate crime so that we can prevent and address. So very quickly, those were some of the key ideas I wanted to highlight from the lessons learned from our experience in talking about the UN standards and norms in crime prevention, criminal justice, but also on program identification. I'm just going to quickly refer my email and my contact details. What I'm sharing is also a QR code that takes you to the Access to Justice page. And just to quickly finish, next month, we will be hosting an Equal Access to Justice for All meeting, which is going to be held in Brasilia. And we will have a civil society consultation, a hybrid civil society consultation. So it's going to be in person and online. If there is interest in participating in the hybrid part of the consultation with civil society on access to justice, please do reach out, and I'll gladly share some details so that you can register and see if we can proceed with an online participation for now, let's say. Yep, so thank you.
Thank you so much, Edwin. I think it's been really great that we had a speaker from UNODC instead of our usual suspect from the CRPD, the CRC, or the CEDAW committees. And I think it's also recognizing how important this topic is and how it's cutting across all teams.